Being a child of a deceased landowner does not automatically give you the legal authority to sell the land. When a person passes away without leaving a will, or where the will he left is invalid, he is said to have died intestate.
Anything can happen in this life.
Please note that this discussion relates to estates governed by the general law of succession, that is, statutory law. Different rules may apply where the deceased was subject to Islamic law or customary law. When a person passes away, everything he owned at the time of his death forms part of his estate. An estate simply means all the property, assets, rights, and interests owned by a person at the time of his or her demise, including land, houses, vehicles, money, investments, and other assets.
Hallelujah.
Now, here is the important point. When a person dies intestate, letters of administration are generally required before anyone can lawfully deal with the estate of the deceased. Letters of administration are legal documents issued by the probate registry authorizing specified persons known as administrators to administer the estates. Without letters of administration, the children generally have no legal authority in their capacity as beneficiaries to sell the property, no matter how genuine their intentions may be. And if they do sell, the buyer may end up purchasing from persons who had no legal authority to transfer the property in the first place. This is where many property buyers make costly mistakes.
Put your ear down. Put your ear down.
They see the children in possession of the property and assume that ownership and the authority to sell automatically passed to them. The law does not always work that way. So before proceeding with the transaction, a prudent buyer should ask for the letters of administration and verify them at the probate registry. This process is generally governed by the applicable administration of estates law and probate rules in the relevant states. After the estate has been properly administered, the property may then be transferred to the beneficiaries through a document called a deed of assent. A deed of assent is the document that transfers ownership of the property from the administrators of the estate to the beneficiaries. Once a deed of assent has been executed, the beneficiaries may then be entitled to deal with the property in their own right, including selling it.
God will bless you.
Think of it this way. Letters of administration give the administrators authority to administer the estate. The deed of assent transfers the property from the estate to the beneficiaries.
You get it?
So before buying property from the children of a deceased owner, do not simply ask, "Are you his children?" Also ask, "Have letters of administration been obtained?" And before you make payment, you must verify the letters of administration at the probate registry. Where the property is being sold by a beneficiary, insist on seeing the executed deed of assent. Conduct proper due diligence, including searches at the land registry and the office of the Surveyor General. Because being a child of the deceased and having the legal authority to sell are not always the same thing.
If you don't get it, forget about it.
So if you buy property without carrying out these checks, you may discover too late that you have bought property from someone who had no legal authority to sell it. So handle it wisely.